Well, hello, and how are we all today? Yes, I thought I'd come out of hiding or assignment fatigue and come on and catch up with all the goings on that is around the place. So I hope you are all well. Welcome to my channel. My name is Joanne. We talk about a whole variety of things, and apparently it's my channel's birthday. Happy birthday to my channel. Happy birthday to my channel. Happy birthday to my channel. Happy birthday to me. Yeah. So anyway, it's my channel's birthday apparently. So we are. I don't know. We've been going for a while, but I've probably been taking it seriously for a few years. Today I want to talk about the 7M response to Katie Joy's motion to dismiss that was filed over the weekend. I want to talk about the countdown to the Australian election. Hello, Vanandra. So it's Sunday night. So next Saturday night, we will find out whether we have a new government or not. The Fox is already celebrating. I don't know whether you're celebrating it's the fact that it's the channel's birthday or you're celebrating a new government, the Fox, or whether you've started to celebrate, or whether you're starting to celebrate the fact we could have a new government by next weekend. But we've got all of that to do, so that's all happening. Both the Fox has said both. Things aren't looking good for the current sitting government. Yeah, so it's definitely going to be interesting. Hello, Totally Clueless. And I want to look at the Duggar sentencing because I've been doing, I found the US Federal Sentencing Act guidelines, and I thought we'd have a look at that to see whether we could understand where the judge was coming from. And I found another, and I wanted to talk about the letters that were written to the judge. And I wanted to talk about a Facebook group that is a real advocate, a Facebook person that is a real advocate and actually explains a little bit as to why Anna Duggar would have written the letter she did, and to give us a little bit of background. Hello. And I've just decided to come on. The LNP in more trouble than 2-foot plumber in a Mexican restaurant. I'd say it would seem that way. It would seem that way. I mean, I've been, for those of you that have been regulars on my channel, Friendly Geordies, he has been pretty blatantly obvious about where he stands and about stuff about the current government. Swollen Pickles is another person that I've promoted quite heavily at times. Swollen Pickles has done a very good video on the battle between the Treasurer Josh Frydenberg and the Independent Monique Ryan, and has actually gone and fact-tested quite a few of the statements from both of the candidates, which was really, really interesting. So let's look at, first of all, we'll start off with the 7M results. Now, I'd seen all this stuff on Twitter that Katie Joy's motion to dismiss had been denied and everything. Let me just tell you that it's a proposed order. Quite often when they file documents or motions, they put documents into court. So Katie filed to say that they wanted their document to succeed. So what they do is this is a proposed order. So you can tell it says proposed order or document. I'm just going to write this down so that people who are on replay crew can follow along at home. For those of you that are playing along at home, what are we? 559. Motion to dismiss. Okay. So first of all, the heading gives it away. It says a proposed order. So 7M is saying to the judge, if this works, don't worry about your paperwork. We have done it. You just need to sign it. So the above came before the Honourable Michelle A. Davis, Judge of District Court, on the 27th of May 2022 on defendant's motion to dismiss. Amber J. Stabbing, Esquire, appeared on behalf of plaintiffs. Kristen C. Hendrick, Esquire, and Graham M. Martin, Esquire, appeared on behalf of defendants. Based on the filings, records, proceedings, it is ordered the defendant's motion to dismiss is denied, and the defendants have 10 days to answer to the plaintiff's amended complaint. Dated, signed. So that is what they've signed. They've said, Judge, just sign it. Now, here's the thing. I mean, I'm interested they didn't actually ask for their costs to be paid, because I know in Australia often they ask for a cost order. So Katie Joy, we read, filed a motion to dismiss. This is their response. Now, I have to say, I thought there was just a little bit of shade in this. I actually really liked it. I thought it was a little bit sassy. Now, what I do like about this, so one of the things that we have to do in all of our writings in law school is if we make a point in law, we have to use a case to back it up with. And that's what they do here. They make a statement, they refer to a case. They make a statement, they refer to a case. Now, we are not going to go and look at every case to make sure that it is correct, but a judge might. So let's have a look. This memorandum is submitted in response to defendant's motion to dismiss. Plaintiffs contend that the defendant's motion to dismiss is improper, without merit, as plaintiffs have properly pled each of their 9 claims against the defendants. As such, plaintiffs respectfully request that the court denies the defendant's motion to dismiss. Hello, birthday girl without a lawyer. Was it yesterday or today? Happy birthday to you. Happy birthday to you. Happy birthday without a lawyer, Peter, without whatever you are. Happy birthday to you. So there you go. All right. So, Peter, without a lawyer, just had a significant birthday. Anyway, so the big 50 today. Wow. Oh, I do need to talk about something else as well later. But yes, so it's without a lawyer's birthday today. So say happy birthday. So this is the response that 7M needed to reply to her motion to dismiss. And we know that her motion to dismiss was a copy and paste job. So this is what they've said, legal standard. A dismissal is proper when plaintiff's complaint fails to state a claim for which relief can be granted. So they've got here the Minnesota Civic. So that's the law. E. In determining a motion to dismiss for failure to state a claim, the court only determines whether the complaint set forth a legally sufficient claim for relief. Here they've stated a case, Baker versus Best Buy store. And this is where you can find it. Sometimes it's the page number or the reference number. So you can put that into your legal. Your legal case search. You can just copy and paste all of that into the legal case search and come up with the case. It's great. So this was from the Minnesota Court of Appeal in 2012. The court reviews the complaint as a whole to determine whether, as a matter of law, a claim has been stated. So then they've got from Martins and Min. Again, this is from a case in 2000. A claim is sufficient against the motion to dismiss for failure to state a claim if it is possible on any evidence which might be produced consistent with the pleader's theory to the grant relief demanded. Now here's another case, Walsh versus US Bank. Again, this is a 2014 case. This is added Northern States Power Co. versus Franklin, a 1963 case. All inferences relating to facts pled must be drawn in favour of the plaintiff and the court must presume all alleged facts are true. So remember, they have to presume all the facts the plaintiff state are true, alleged are true. And then they've quoted Walsh, citing Barber and Capella University, and from 2010. Now, this is where we get really interesting. Defendant's motion to dismiss only addresses 2 of the plaintiff's 9 claims. Remember, they put together 9 claims. Katie Joy only addressed 2 of them. So here's the issue. Does that mean that 7 are true? Does that mean that she's only got defences for 2? Or is she hoping the other 7 will disappear? Let's see what they say. So she only addressed 2. So they said that the plaintiffs set out claims against defendants for defamation, defamation per se, tortious interference of contract, commercial defamation, intentional infliction of emotional distress, negligence per se, that's a Minnesota statutory law, deceptive trade practices, another statutory law. So remember, statutes or statutory law are against the government. The others are torts or civil. Intentional inferences with prospective advantage and injunctive relief. So there would be a statute. So that's a statute. So if we were to look up that Minnesota statute, that will tell us all about negligence per se. The rest are common law, by the way. The rest are common law, which is judge-made law or interpreted law. The statutory law is government. However, in their memorandum of law in support of defendants' motion to dismiss, defendants have only attempted to dismiss for count 1, defamation, and count 3, tortious interference of contract. Plaintiffs have set forth 12 pages of factual allegations in their complaint, which support their claims. Examples of these factual allegations are that plaintiff committed various crimes, including human trafficking, kidnapping, waterboarding, and plaintiffs are leaders and members of a cult. Plaintiff's complaint at 26. The relief requested by plaintiffs is consistent with the legal theories pled as well as factual background of this case. The plaintiffs have properly pled numerous claims for which Minnesota laws may grant relief, included significant factual allegations to support these claims, and asked for relief commonly granted by Minnesota courts. Defendants' motion to dismiss must be denied. Right. A totally clueless says, I swear she writes this stuff and I swear she pays the lawyer to put it out. So now, they're actually now they're now responding to the 2 counts that they've just said to the court, you know what, we put forward 9 claims. They've only mentioned 2. So these are our 9 claims. They've only dealt with 2. But let's deal with what they've told us. Defamation. Plaintiffs have properly set forth a claim for common law defamation in count 1. Oh, I said it was common law of their complaint. Minnesota is a notice pleading state and does not require absolute specificity in pleading, but rather only requires information sufficient to fairly notify the opposing party of the claim against it. So, they only have to, she can't get away with the cult label, especially after telling lawyers they must be part of the cult if they have documents. True, Short Order Cook says. So they only have to state that there is sufficient. They only have to just state that this is what we believe it to be defamation. They don't have to spell it out. They don't need to supply the evidence. So at Walsh at 60405, under Minnesota law, the pleading of broad general statements that may be conclusory is permitted. Quoting Barton and Moore from 97. So a pleading will only be dismissed if it appears to a certainty that no facts which could be introduced consistent with pleading exist, which would support the granting relief demanded. finding the claim for defamation was sufficient to defeat a motion to dismiss where the plaintiff's pleading sufficiently put defendant on notice he participated in the commission of the tort of defamation. So, they only have to show that there is some defamation. They don't actually have to say, of common law defamation in Minnesota. So now they're spelling it out really simply, the elements. So when we talk about defamation, or we talk about elements, what are the elements? So what do you need to prove? So for example, if you're talking about negligence, there are certain elements that have to be met, or things that have to be found so that they can go, yes, it's negligence. So now we're talking about the three elements of common law defamation in Minnesota. So the elements are that the defendants made a false statement to someone other than the plaintiff, and that the statement tended to harm the plaintiff's reputation and lower them in estimation of the community. They're the three elements of common law in Minnesota. So thinking about what you've seen, would you say yes, yes, yes to all three? They're the three things that need to be proven for it to be defamation in Minnesota. So in this one here, plaintiffs have pled each of these elements in its complaint. So they've said from the plaintiff's complaint 31 to 40. Plaintiffs have also pled facts which support each element of their claim for defamation. Paragraphs 13 to 29 of their complaint. If each of the factual allegations in the plaintiff's complaint are construed as true for the purposes of this motion, the plaintiff's claim for defamation would succeed. Okay, so go over them again. Okay, so the three elements, I'm going to try and make this bigger again. Is that better? So we're looking at the elements. So for it to be, so the elements of common law defamation in Minnesota are that the defendants, 1, made a false statement, 2, made the statement to someone other than the plaintiff, and 3, that the statement intended to harm the plaintiff's reputation and lower their estimation in the community. Okay, that are the elements of defamation. That's what you've got to prove. That's what you've got to prove for defamation in Minnesota. So what I'm saying is, do you think that they've met those elements? So they're saying they have pled the elements in their complaint. So remember, it was stated before that if each of these factual allegations in the plaintiff's complaint are construed as true for the purposes of this motion, then the plaintiff's claim for defamation will succeed, as plaintiffs have pled sufficient facts and allegations to support a claim for defamation against defendants and to put them on notice for saying defendants' motion to dismiss improper and must be denied. Defendants in their memorandum of law allege plaintiffs cannot meet the heightened standard of defamation. Oh, you're going to love this, B. I actually laughed and laughed and laughed. Okay, so here we go. Defendants in their memorandum of law allege plaintiffs cannot meet the heightened standard for defamation regarding actions against the members of the media by public figures. This two-part argument is wholly unsupported by any law, in fact, contrary to well-established federal and state law. Plaintiffs expressively object to defendants' attempt to judicially notice the court and opposing counsel that, 1, the defendants are members of the media, and 2, plaintiffs are public figures. So they expressly object to the fact that the defendants are stating they're members of the media. Okay, so defendants attempt to argue the merits of this case in their motion to dismiss to further proof that their motion is improper. As to the plaintiffs regarding their alleged status of members of the media, There is no blanket exception which precludes a member of the media from being named as a defendant in an action for defamation. There are instances where qualified privilege may be taken into account as an affirmative defence to a legitimate defamation action. However, a motion to dismiss is not the improper avenue to assert these defences. Although plaintiffs assert defendants are not members of the media, defendants have the opportunity to present any affirmative defences, including any media defences, in their answer. So they're asking, and again, they're saying a motion to dismiss, just that for journalism, is that's not really the proper basis. I mean, they should have defended it, to be perfectly honest with you, but any potential leader. Second, plaintiffs are not public figures, limited public figures, or public officials, which would subject them to any additional element of actual malice necessary to prevail on an action for defamation. Such a determination is an issue of law for this court to consider after proper briefing. Without conceding the issue of plaintiff's status as public figures, plaintiffs did plead actual malice in their claim for defamation. Plaintiff also pled facts which are consistent with pleading of actual malice. And again, they've stated where they've stated that. Even if plaintiffs are considered public figures, the amended complaint probably pleads actual malice and contains facts which support this pleading. A final determination of actual malice is not required at this stage in pleadings. Plaintiffs merely need to show that they properly put defendants on notice as to their claim for defamation. Plaintiffs have sufficiently set forth not only their claim for defamation, but also included allegations and facts above and beyond the minimum required to survive a motion to dismiss. Plaintiffs' amended complaint properly sets forth a claim for defamation against defendants and contain a legally sufficient claim for relief. Defendants have failed to meet the burden of proof to grant a motion to dismiss. Therefore, respectfully request that the defendant's motion to dismiss be denied. So that is their response to her only one that she responds. So now we've got count 3, tortious interference of contract. So remember, there was 9 that she commented on, and she only mentioned 2. Plaintiffs have properly set forth a tortious interference of contractual relationship. The course of action for wrongful interference with a contractual relationship requires, this is actually good too, 1, the existence of a contract, 2, alleged wrongdoer's knowledge of the contract, 3, intentional or procurement of its breach, 4, without justification, and that should be, and 5, damages. And again, there's a case there to back that up. Plaintiffs have pled each of these elements in its complaint. Plaintiff has also pled facts which support each element of their claim for wrongful interference of contract. If plaintiffs have pled sufficient facts and allegations to support it for the tort of wrongful interference of contract against defendants and put them on notice of the same, defendant's motion to dismiss is improper and must be denied. Defendants allege in their 2-sentence argument shade. Defendants allege in their 2-sentence argument against plaintiff's tortious interference of contract claim, there is no allegation in the amended complaint that the Clippers contract was breached. Defence memorandum of law in support of motion to dismiss. As stated above, Minnesota is a notice pleading state and does not require absolute specificity in its pleadings, but rather only requires information sufficient to fairly notify the opposing party of the claim against it. Okay. Plaintiffs plead defendants intentionally procured a breach of the contracts between plaintiffs and third parties. Plaintiffs' complaint 60. Plaintiffs did specifically plead that defendants breached not just one contract with the LA Clippers, but numerous contracts between plaintiffs and third parties to this suit. Additionally, plaintiffs pled that defendants continued to direct their followers to convince third parties to cancel contracts with plaintiffs. Plaintiff's complaint, paragraph 56. Plaintiffs in their complaint have sufficiently met the pleading requirements for tortious interference of contract. Therefore, defendant's motion to dismiss is improper and must be denied. Defendants also claim it is unlikely that the contract is breached, as there are commonly escape provisions in commercial entertainment contracts. Defendants cite no case law to support this conclusory allegation, and attempt to bolster their argument by claiming, since defendants do not currently have a copy of the Los Angeles Clippers contract, plaintiffs cannot support their claim. There is no law which states a lawsuit must be dismissed where a plaintiff has not provided full discovery to a defendant upon service of a summons and complaint. None of the defendant's statements regarding plaintiff's claim for tortious interference of contract support a motion to dismiss. None of these statements provide authority which would allow the court to dismiss plaintiff's claims. They should be disregarded, and a motion to dismiss should be denied. I love that, because they're saying, since the defendants don't have a copy of the LA Clippers contract, therefore there can't be a contract. Anyway, remember, all of these, but from my understanding, from what I can work out, it's in discovery that all of this information comes about. There only has to be enough for them to say, yes, let's go to trial. Okay, so here's the conclusion. Defendant's perversion, what a word term, defendant's perversion of Minnesota law and inability to apply the facts to allegations does not negate the validity of plaintiff's claims. Plaintiffs have pled specific facts and allegations which support each and every one of its 9 claims in this lawsuit. As such, plaintiffs must be allowed to move forward on the merits of their lawsuit. For the foregoing reasons, plaintiffs respectfully request the court denies the motion to dismiss and issue an order giving defendants 10 days to submit an answer in this matter. Short Order Cook says, I would have put total disregard. The word perversion is actually very that she's fixated back on Josh Duggar. Perversion is quite an interesting word. So that was filed on the 12th. So on the 27th of May, we will find out. We will find out what's happening there. But as I said, the fact that they've backed it up with law, and it seems to be solidly written, in my opinion. I know that I don't know much, but it seems to be solidly written, and they've seemed to have really I don't know what I'm trying to say. They've put her on notice. They've really counter-argued everything. So I'm going to go on to Josh Duggar's sentencing now. Well, we're onto that, and then we'll have a chat about Aussie politics. So we know that Josh Duggar's sentencing is coming up, and Short Order Cook says it's concise to the point, not flowery. They're serious. I think so. Now, I came across this site the other day. Someone sent it to me. So it's a website blogger called Thriving Forward. Now, this woman is a real advocate. Now, she says her name's Emily. You can call her M. She grew up in a home with DV and was raised in a fundamentalist patriarchal church for 23 years. So patriarchal cult. And she left. And she started a personal journey, and now she helps other people recover. Now, she wrote something very interesting. So I'm just showing you her website. First of all, and if you like, because I thought, yeah, what, you know, I didn't want to do that. How did I get onto that? What I found very interesting is that she talks about David Waller, which is Anna Duggar's brother-in-law. Is it brother-in-law? And stated that he was. I'll show you. Let's get this up. So this is Thriving Forward, and she's got a blog. So this is David Waller, pastor Fairbank Baptist Church, written on March 10, 2022. I urge you to consider how much his wife and 7 children need him to be in their lives, to be nearby for visits, accessible for communication, brought back home, to provide not just financial but spiritual guidance of his family, David Waller. Now, this is what she says. David Waller. David is Anna Duggar's brother-in-law and recently wrote a letter to the judge he's going to sentence Josh Duggar soon and asks for leniency. David also happens to be the man who sat nearby and literally watched Bill Gothard groom me for a week when I was a teenager. Hello, Plan to Create. How are you going, Plan to Create? Are you feeling better? So she was involved. We know where she was. We know what she knows, okay? So she was groomed by Bill Gothard. Bill would have me up in his office at late night grooming me, and David would be sitting on the other side of the room saying nothing. He also helped Bill formulate ideas on how to convince me to stay at headquarters long term, right? So that's her background. So when she wrote something about Anna Duggar, and I'm not going to read the letters, but I'm just going to read what she's written here, because I think, and I'll try and make this bigger. How do I make this bigger? I do it when I don't want to do it, and then when I want it to happen, I can't do it. I don't know. Not yet, very slow process. This is what she's written, okay? So she's got a copy of the letter down here from Anna. Now, here's the thing. I'm going to be very controversial here. From what I can see here, this is a typed written letter. How do I know? How do I know, or how do we know, first of all, that Anna Duggar actually wrote it? That's my first question. How do we know that Michelle Duggar wrote hers? Right? How do we know? So my thing is, Katie Joy always goes on about how all these women are obedient and subservient and all of this sort of stuff. Why couldn't one of the men have written the letters? Thank you very much, Bella Marie. Very much appreciated. So I'm just playing devil's advocate here. Now, I don't agree with everything that M from Thriving Forward says, but she puts it into a little bit of perspective. And this is written by, this for me is somebody who is a real advocate. So let's just see what it says. Over the past year, since Josh Duggar's arrest, the world has watched his wife Anna stand quietly and unwavering by his side. Shortly after Josh's conviction last December, Anna broke her public silence with a one-sentence tweet. There's more to the story, and attached a link to the motion from the defense team outlining their theory that was framed and truly innocent. Multiple people close to the family have stated that Anna is fully convinced of Josh's innocence. And just this week, the world read with jaws to the floor letter Anna recently penned to the judge, begging the court to return Josh to her and her children soon. While none of us really know exactly what Anna Duggar is thinking, let's approach this subject from the standpoint that she does, in fact, believe in her husband's innocence, despite a grueling trial that clearly presented the mountain of evidence that proves his guilt. How could this be possible? Because when the body is enduring extreme trauma, it will find a way it can to protect itself. And so I'm going to just put a trigger warning up, because I just really want to, we're gonna go there. So that's a very interesting point, though, that she's made. when the body is enduring extreme trauma, it does some really strange things. Okay? So let's think of what would have happened if she accepted the truth. She would have had to accept the truth. So she's written it now. If Anna was to actually accept the truth, she would have had to accept the truth that Josh was not the wonderful, good man she'd hoped to marry, and that all her efforts of going through courtship and staying a virgin didn't secure her a godly husband as she was promised it would. She would have to accept that Josh was never truly reformed and that he has continued to deceive her since his infidelity became public knowledge in 2015. She would have to accept that he was a predator and should never be allowed around her children again. That would mean that she would need to live separate from him once he is released from prison, and her now 6-month-old baby would be their last baby. She would have to accept that she married naively. She knew during the courtship to Josh that he molested several of his siblings a few years before, and though I highly doubt she knew how serious the situation was, she was still very naive and brainwashed by the cult she grew up in and was not given the proper tools to make wise choice. She would have to accept that her very children have been lightly essayed. Seriously, if you're a parent, sit with that for a moment. She would have to accept that she'd been lied to, manipulated, and used for the last 15 years. For Anna to accept the truth of his crimes meant accepting the truth that she married a monster. And that kind of devastation can be a living death sentence for some people. I'm not saying it's impossible for her to get therapy and get healthy. Yes, she has options. She can do what countless of other survivors have had to do when their life seems forever shattered. But in order to rebuild and heal from this, she would need to walk through a whole lot more hell than what she's already been through. Because for the first time, she would have to sit aside her body's natural defense mechanisms and fully face and process through an unimaginable level of grief. So what about the children? I believe Anna is fully a victim. Anna is not just as bad as Josh. See, she's no monster. She has been raised in and is still surrounded by an entire system designed to cripple her and remove autonomy. But in cases like this, I do believe it's possible that some victims can sustain such extensive trauma, brainwashing, and damage to their nervous system that they become unable to make the decisions necessary to appropriately care for any minors in their charge. I do believe as long as Anna desires and is pleading to expose her children to Josh, she poses a risk for them. And therefore, authorities should be investigating the best options for their children. Because above all else, those children need to be protected. So how could Anna believe in Josh's innocence? Because fear is a powerful drug. One of my readers said it best last night: the paralyzing effect from that kind of fear can be stronger than a maximum security prison because the bars are in her own heart and mind. Emily goes on to say, I pray Anna will one day be surrounded by a support system who is willing to help her tear down those iron bars. I pray she gets connected with a good therapist who will speak truth into her and give her the tools she needs to process her grief, build healthy boundaries, and take action to protect her kids. And I pray one day she realizes that this monster she married does not define who she is. Now, as I said, that was written by somebody who lived in the cult, escaped to the cult. And I think it gives you a bit more of a perspective of why it is that she did, why she has written that. And as I said, she's grown up to believe that she can't survive without him. So of course she's gonna want him back. Look, I don't know. Well, the thing is, but I don't know whether she's been brainwashed, but she would know of no other way of life. She doesn't know that there is. She could possibly really believe that without Josh, that her life isn't worth living. So that was from an advocate from Thriving Forward. Then we have this from the other advocate, which I find to be disgusting. Anna Duggar loves being a kept woman. She's been brainwashed into entitlement where women can send a letter to the judge and demand he send her husband home to work for her. In the real world, men are incarcerated daily. These men are fathers, husbands, providers. Their wives find a way to make do for their children. They enroll in food stamps, find subsidized daycare, and find jobs. Some divorce their spouses, especially those caught by being SOs, and you know that word. No judge will be swayed by pleas that your husband needs to come home to work. You should have thought about that before downloading the most horrific CSAM online. Not once did you think about the children in those videos. Yes, your children are sad, but they're safer without your husband. She's written pedo. The kids in the videos will live with the trauma for the rest of their lives. Your husband gets off on their trauma and abuse. That's sick. Your children are not safe with Josh, and I'm worried they aren't safe with you given your inability to protect them from Josh. Get a job. The money train is up. It's done. And she calls, that to me is horrifying. Why? That is absolutely disgusting in my opinion. That is not an advocate. She was brought up, it's totally clear to say she was brought up with the belief that fathers, husband, brothers are to be honoured regardless. Her parents arranged courtship, and I sat there while watching while he proposed. And Short the Cook says, I'm not being disrespectful or disregarding, but misplaced trust in any partnership will be devastating. And this doesn't depend on the cult. A marriage can be grooming to... Oh, exactly. It doesn't necessarily have anything to do with a cult. But I just find that the two differences, the difference between an advocate. So she couldn't really say no. Zeb did a body on her body language at the time, and she was really uncomfortable. Look, I don't believe she could have said no. But that's just my belief. But again, because it's typewritten and there's no signature, it's just a typewritten one. I can't. How can I be sure that she wrote it? I've become very suspicious since I've started law. We can't go on together with suspicious minds. With suspicious minds. I'm just very suspicious. Now, I actually started looking into a few things. And I have no idea. First of all, I have no idea how this is going to go. But I looked at the United States Sentencing Commission Guidelines Manual. It's supposed to have been Anna Duggar, Short Order Cook, was supposed to have written. So, the Sentencing Act. This is the guidelines in which a judge would have to follow. Now, we're going to go through this and we're going to see whether we can work out how this is going to work. So, I have had trouble, actually, and because I don't have the charges in front of me, and I should really have the charges in front of me, but I just thought about this before. Oh, if you're talking about the Thriving Forward, the Thriving Forward was Emily, who started Thriving Forward, an advocacy group for people in the fundamentalist cult. So, because I can't find what he was. I don't have in front of me what he's charged on, but this is what it looks like. This is the sentencing table. And so what I can work out is that the offences are given a level. Okay, so it's either zone A, B, C, or D. Then this is criminal history. So depending on what their criminal history here. So so the first step in applying is to select the guideline for each conviction. So it provides a statutory index that lists guidelines applicable for most federal crimes. Okay. So the factors determine a base offence level and a criminal history. So each of those factors include a score, so like the X and the Y, which we've just said. The point where the two axes intersect provides the sentencing guideline range. So, for example, the base level shows up in the vertical scale. Example of sentencing range so if it's a offence level 18, it will be 27 to 33 months. And the criminal history characteristics appear here. So they get 1 point for any prior sentence, 2 points for each prior sentence of at least 60 days, and 3 points for each prior sentence of at least 13 months. So this goes here. Now, Josh Duggar hasn't been charged with anything, so he is going to get a criminal history category of 1. So for him to get what Katie Joy is actually stating he needs to be all the way down here. All right. So then they look at special offence characteristics. So whether they abuse the position of trust, where the crime created financial hardship, where the defendant created more than 10 victims. So it's so Zone A are offences tend to be lesser offences and punishable by probation, home confinement, or community confinement. They're lesser type offences, Zone Bs. Zone Ds are unlikely to receive probation as part of their sentences. Defendants with Zone D offences levels usually are sentenced to imprisonment terms of at least 12 months or more. So we know that he's going to have at least a zone. I mean, his is at least Zone D. All right. Bella Marie, I don't know whether he can take that into... I don't know the specifics of whether what he did to his sisters or anything else can be taken into, because he was never charged for it or convicted on it. So this says promoting commercial or prohibited other than a minor. So that's out. So we want a minor. So this is with a minor. Okay. So base level offence 34 if the defendant was convicted under 18 USC, 30 if the defendant was convicted, or 28 or 24. So let's look at what so it could be 24, 28, 30, 34. So let's have a look. 24 is 51 to 63 months. 28 is 78 to 97 months. 30 is 97 to 121 months. So 120 months is 10 years, isn't it? Now, so special, if A, defendant was a parent, relative, or legal guardian of the minor, or B, was the minor, was in custody, care, or supervision, you've got to increase the points. If the offence involved the knowingly misrepresentation of a participant's identity to persuade. So this is, and every state, I mean, even in Victoria, we have this, and there's a sentencing guideline, and it takes you through how the judge needs to go through it all. If the offence involved the use of a computer, interactive computer service to A, persuade, induce, entice, coerce, or to entice, encourage, offer, or solicit a person to engage in prohibited with a minor. If the offence involved the commission, and then if any of those applies, you increase it by, if the offence involved a minor who'd not attained the age of 12, increased by 8. If the offence involved causing, transporting, permitting, or offering seeking notice or advertisement, a minor to engage in conduct for the purpose of producing video. If the resulting offence is greater than the determined above. Look, I'm still maintaining without a lawyer that he's getting 5. So if the minor was killed, then you've got to take that in. If the offence involved more than one minor, Chapter 3, Part D, multiple counts will be applied. So here, and then you've got all the definitions. So a computer. So it's defined. Now, and the other thing is that what you think it is may not always be in the definition. You know, so the minor is someone who's like an individual, whether fictitious or not. Okay, so there's that one. So this is everything that they've got to put in. And then is sexual exploitation of a minor. The base rate is 32. So let's go back to 32. 32 with no prior convictions, 101 to 151. It says 5 years, but he's looking for 8 to 12. Well, as I said, I was just, because, see, distribution, so this is, remember, he only downloaded, I mean, I shouldn't say, make it sound like it's less. He downloaded and viewed it. That's different to actually making it. If you get my point. So if he was involved in making it, he would be in for a lot. I reckon 8 with good behaviour purity has no distribution. There's no distribution. From what I mean, as disgusting as it was, this is trafficking. Look, it's 18 and 22. So 18 is 27 to 33 years. What I will do is I'll just put a link into the chat. You can actually have a look at it for yourself. Okay? United States Supreme Court. See, the thing is, short order cook, he may get time served. The judge may decide on time served. Now, so because the issue is that because he didn't make it, as I said, as horrific as it is, and he hasn't physically engaged in the act with a minor, it's sort of deemed a little less, it's not considered as bad, even though it is disgusting. If you know what I mean. I'm really trying to say this eloquently, but sometimes I'm not very eloquent. So, yeah. If he was distributing it, if he'd made it, I mean, we still don't know whether anything's happened to his children. If any of that occurred, then of course they would put him away for life. Hope the sentence has been updated. No, I believe that is the latest one, short order cook. And again, I could be wrong, but I couldn't find anything later than 2012. So, for example, let me just show you. I'm just going to show you the Victorian Sentencing Act. So that's the state that I live in. Okay. This one goes back to 1991. So the current act in force is the 1991 version of the Sentencing Act. Okay. So this is what the Sentencing Act in Victoria. But they also take, it also, so in here, so again, this is the Victoria, so this is the Sentencing Act 1991 for Victoria. So it talks about sentencing guidelines. Now, court not to have regard to previous good character or lack of previous findings of guilt or convictions in certain circumstances. So then, despite Section 5 to sentencing an offender for a child SA offence, the court must not have a regard to offender's previous good character or lack of previous findings. So in Victoria, all that previous stuff is not considered. Okay. Then it does not apply to an offender who was under the age of 18 at the time of the offence. And that's the other thing to take into account, the age when the offence occurred, by the way. Right? So a standard sentence scheme. All right. And I did look it up. It's only about 5 years in Victoria as well. So serious offenders, factors to consider. So whether they're a serious offender, and it's listed there. So pre-sentencing report, drug and alcohol reports, victim impact statements, how that all works, and then custodial orders. It's all outlined here. So carjacking, just trying to find an when you can invoke an indefinite sentence, community orders, time to pay. Or now there is something very interesting in here. Is it section 9? If he's locked up, he's likely to be put into solitary confinement. So look, mentally ill offenders. So it all goes through how to do all of this. They don't use the royal prerogative of mercy. Yeah. But there is a provision in so again, in Australia or Victoria, they talk about penalty units. Okay, so so a level 1 offence will be a life, a level 2 will be 25 years, and it tells them how to calculate it all. So these are all fines here. I mean, he may even get fined. So it tells them how to do that. There is also a section in here, and I can't find it right at this moment, where if they actually plead guilty, they actually get time taken off their sentence. So it's very interesting how this all works. So this tells about how to, about cancellation of driver's license, compensation. Yeah, so failure to comply. So everything is laid out for them. And so like they have that federal one for the US. I don't know that he has short order court. So as I said, this is the sentencing. This is what it looks like in Victoria. So the power to fine, the maximum fines, it's all here, and they just have to sit down and work it all out. So I doubt that I would doubt that he is going to get 20 years. So anyway, so that's essentially what it sort of looks like. So this is the Sentencing Act in Victoria from 1991. And they just go through the process, you know. And I think, it's very foolish of somebody to get people to riled up about the 20 years, because as I said, I doubt that he'll get it. I'd be very surprised if he gets it. Okay, so let's get on. I just want to put one more thing in before we get onto some Australian stuff, because I before we get onto the Australian news. But today, or this morning, as you know, I like my sport. And today we lost another Australian cricket legend, Andrew Symonds. And I actually was horrified because he's a year older than I am. And he died in a single car crash. So he so this was Andrew Symonds. I did not know that he was adopted. He's an adopted. He's adopted. Was born in England. Was adopted. His adopted parents came to Australia, and he was an Australian. This is his most famous. This is the thing that most people talk about. There was a streaker on the field, and he gave him what we call a hip and shoulder, and took him out. So at the age of 46, Symonds died in a single car crash not far from Townsville in North Queensland. He had so much more to give. He had 2 young children. His wife has made a statement to say, while she's devastated, her heart's breaking for her children. So he says he knew he was adopted from the time he was able to talk. So he moved to Australia when he was 15. He could have played for England, but he chose to play for Australia. So he was introduced in the 2003 World Cup, and he made an impact. So he had dreads. He also, the glitz and glamour of professional sport never appealed to him. His escape was found on a boat or on a river, fishing right in hand, and after a day's work was done, a beer or 2. Drinking threatened his career. In 2005, he turned up for a one-day international against Bangladesh and England, still drunk from the night before and unable to stand up. He worked hard to keep his drinking under control, and he actually was able to work on that, and cut down his drinking a lot. Now, there's also what's known as the in 2008, there was an incident. Symonds alleged that Indian spinner Harbishar Singh had called him a monkey during the test. He's corroborated by the Australian teams. The International Cricket Commission handed Harbishar a 2-match ban, only to degrade that from an appeal from the Indian Cricket Board. India threatened to boycott the rest of the tour. As Simons at the tribunal alongside Matthew Hayden and Michael Contin, he was racked by guilt that he dragged his teammates and friends into a highly political mess. There would be no suspension for Harbinger, no boycott from India, just the hollowness from Simons that would never be filled. The racism would haunt him for years to come, and he felt that he'd been let down by the Australian career of cricket. He would admit to having problems with binge drinking, and he essentially lost his international cricket career. So in 2012, he retired from cricket to spend some time on the T20 cricket circuit, and dedicated himself to his family. He lived in Townsville with wife Laura and 2 children, and they lived a simple life as he surrounded himself with people and places he loved. He became a familiar voice during the Big Bash commentary, and his unassuming and modest analysis stood apart from contemporaries. I don't like using the word simple. However, I found that he was relatable because he actually spoke to the common person, you know. He remains beloved by those who follow the game, and he'll be ever known as Roy. So Andrew Simons will now be forever feel unfinished but never unfulfilled. So now what was interesting is that there have been reports out that people went to help him. He had two dogs. Two dogs with him. His 2 pet dogs were with him in the car. They both survived. One of them guarded him very closely, and as the people were trying to get him out of the car, was barking at them and growling at them, as they do when they love their owner. So, that's really. So anyway, so we've lost 3 cricket. We've lost Rod Marsh, Shane Warne, and Andrew Simons this year. It's a bit sucky. Alrighty, let's get on. So, Saturday, May 21 is election day in Australia. It is compulsory for everybody over 18 to vote in Australia. Yes, it is. It's compulsory. We are supposed to vote. It's the way I'm still going to do it. My plan is to do a how to vote and how to set your own preferences in Australia, because I really want people to know how to vote so they make their vote count. I've still got to do that. Which is, so I'm really interested to see what people think could happen. I know what that is. I'm just going to show you something. For those of you that are from Australia, if you've got some issues, you can actually do this. And I'm going to show you something. This is my personal pocket guide. So this is your personal to the 22 need help with voting. So I'm in the electorate of Gellibrand. Okay. So it gives me all the places that I can vote. So where I can go to vote. So I don't know. I'm just going to pick one, because I don't know where I'm going to. I actually don't know where I'm going to go to vote. Oh, I can vote there. Right, I'm going to pick one that's a little bit further away from me, right? And so click next. Now, here is the thing. This is what I love, right? You can print this out. So there are 8 candidates in my electorate. Click the boxes to preference your vote. So here's the thing. We've got the Australian Greens, the Liberal Party. We've got the Australian Federation Party, Victorian Socialists, United Australia Party, Liberal Democrat Party, Pauline Hanson's One Nation, and the Labor Party. Now, if I want my preference to go to the Liberal Party or the Coalition Party, I would put No, I don't want that. You've done it the wrong way. I want that to be 8. I vote backwards. I always start. So I'm going to, this is not how I'm voting, by the way. I'm just picking. I'm just randomly clicking. All right? Now, what happens is, when this goes to the counting, Andrew Charles will have a post pile of votes with a 1. That goes to him. Now, because we have a 2-party preferred system, it comes down to between Monica Clark and Tim Watts. What happens is all of Andrew Charles's votes get picked up and they're redistributed. So they go, who has the higher value? In this case, the preference would go to Monica Clark because 7 is higher than 8. Now, if I was to reverse that, Labor gets the preference, meaning it doesn't matter what I do for 1 to 6, as long as the preference goes to the party that you want to get your vote. Okay, that's how that works. So if I was going to do that, okay, it doesn't matter whether that this could be 4. I mean, this could be 2. This could be, I mean, you could do it 1. You could do it that way. It doesn't matter. Okay. Right. So we're going to leave that there. Right. So then click. So I always vote below the. Oh, this one's wrong. I don't like this one. At least 6. You got to do 6. I like 2. This is above the line pay. This is above the line voting. I never do above the line voting. I always do below the line voting. Now, this is the Senate. The Senate is the upper house. Okay. So this they've set this up for above the line. You've got to do 1 to 6. When you do below the line, like I do, you've got to do 1 to 12. Now, the Senate is the house of review. You don't want the party that is in government to actually have the majority. I'm on the ABC News site Personal Pocket Guide. I'll give you that link. You know what? Every year, every election, I print it out and I take it with me. Do you know how easy it is to copy and paste? Right. So, if I've given my preference to the Labor Party, I'm going to give my preference to the Liberal Party. Why? Because I want there to be a balance. And then it doesn't matter who else I put in. If I gave my lower house preference to the Labor Party, sorry, if I gave my preference to the Liberal Party, and I needed to preference so then I would preference the Labor Party in this one. Okay, so we've got that. Right. So then what you do is you print this out. So you can email it to yourself or you can print it. And it tells me that I can go to this place between 8 and 6. That's how I would fill out my... So I'm just going to change this for a minute. Remember, I said it doesn't matter. So in this case, I'm going to preference the Liberal Party because I don't want people. So in this one, I would preference the Labor. This one needs to have the Labor Party first. So then what happens is you print this out or you take a copy of it. And when you get to the ballot box, you start at the top and you go all the way down. So just to recap, I personally always start at 8. The party that I don't want to win, the party that I am opposed to, I put 8. So for this example, I've put the Labor Party. Okay? But so if I've put the Labor Party if I put the Labor Party on this piece of paper, I'm going to put the Liberal Party higher on this piece of paper. If I'm going to put if I'm giving my preference to the if I'm giving, oh, if I give my preference to the Labor Party on this piece of paper, then I have to give my preference to the Liberal Party on this one. Okay, so in this case, I've preferenced the Labor Party because I've put number 8 as the person I don't want to get. My preference has gone to the Labor Party, and I've given my preference to the Liberal Party because why? Because the Senate is the House of Review. It is the job of the Senate to scrutinize the legislation the government wants to bring in, and get amendments. That is their job. So that is how I do it. I hope that's been helpful. And sorry to everybody from overseas, but as I said, it's a preferential system. So other than everything other than the Labor Party and the Liberal Party in most seats gets redistributed. So as I said, this Andrew Charles pile would get picked up, and you would then look at it and go, who's got the preference? Which number's lower? Is it Monica Clark or is it Tim Watts? Well, you know what? There's a lot of people totally clueless that are saying the same thing about our election. So if you're not sure, as I said, go to this website. Oh, you got your new puppy? You get your new puppy tomorrow. So again, if you're going to an early voting system, so you can put in how you can do it, if you're doing mobile postal vote, however. But as I said, it's really important that you understand that we're a preference system. And so that way, if you've already got your votes printed out, you can say, I'm sorry, I don't need any of your propaganda. I've already worked out who I'm voting for. I've got my piece of paper. Yeah, so I do that. I generally do that every year. That's what I do. Sorry, every election. I go and I do the pre-filled parts out. So, hello, Mama Duke, how are you? Now, I thought it was very interesting, though, that a week out to the election, there's 1 week to the election, and the government had their campaign launch today. A week out. Is it too little, too late? Now, I have issues with the he announced this 6 days out from the election, and they've done a campaign launch. I think Shadow Housing Minister Jason Clare described their new policy as the last desperate act of a dying government. I think so. Manifestos, and then remove belief in half of them. Oh, look, I don't believe half of them. This is the treasurer at the moment. I don't think he's going to win his seat. I think he's going to be he's likely to lose his seat in the election. It's likely to go to an independent. And the word is, I can't get it to work because I won't put, yeah, we'll put in somebody else's address nearby. Yeah, because initially I just put in my suburb and it wouldn't let me, so I had to so here's the other here's another interesting Josh Frydenberg. Of course he is. Have you seen Swollen Pickles? Has anyone seen Swollen Pickles videos on this? Huh? If you've got somebody that's in the same electorate as your short order cook, just put in their address. Say put in your neighbour's address. Oh, a French bulldog. Nice. if you've not seen Saul and Pickles, I'm going to put a link here, because Saul and Pickles has actually done some, really, and so has Friendly Geordies, has done some really amazing videos, particularly about the election campaign and the battle for Kooyong, which is Frydenberg's seat. He can get all the spam short articles. Exactly. Oh dear. So have a look at Swollen Pickles. Swollen Pickles has done this. It's got 19,500. I was watching Swollen Pickles today, and I've kept. I watched a little bit of it, but don't run away from the interview or debate. What's the deal with the Federal Independent Integrity Commission? ScoMo's election campaign launch, introducing the 18. How many zeros in 2.1 trillion? I don't know. I don't know what's happened to Bobby. All right, let's have a look. You've been watching Swollen Pickles? Yeah, I'm happy to, Here
are the facts. It is a $2.1 trillion economy. That's right, 12 zeros. Why did you lie to me? He didn't miss it by that much. He missed it by that much.
Yeah, he has a Gladys collection too. He does. He was very good with the Gladys collection. So yeah, I like Swollen Pickles. Even, if you really want to understand, the Gladys collection, random political stuff, some of the things that we're dealing with in Australia. The other interesting thing is that Australia has now ranked highest with the number of COVID cases in the world, and nobody's talking about it. And I was reading that they're expecting it to get worse. And yet nobody, not one political leader, has spoken about what they're going to do. So COVID infections in Australia have hit a worldwide high. I, fortunately, have still avoided it. I've still not got COVID yet. I'm waiting. So we became a world leader in Australia this week, but it wasn't for a feat of engineering or some sort of. According to the global database, Australia is leading the world per capita of COVID infections, if you ignore the entirely owned islands of Montserrat and the Falklands. Really, everybody I know, short order cook, has COVID. On Friday, 54,591 cases were reported across Australia on the back of 2 consecutive days of 58,000, with Western Australia bracing for more. Saturday's number moved the official 7-day average to more than 48,000 daily cases, putting Australia behind only Germany and the US in the total of daily number of cases recorded. Some countries, such as Denmark, have scrapped COVID testing recommendations. Others have scaled back regimes, meaning getting like-for-like comparisons across the world is more difficult. However, in Australia, hospitalisations and deaths are also tracking upwards, with the average number of COVID-related daily deaths hitting 40 since March. Now, I did see some that Nick Coatswaite say that we're still one of the few countries that are still recording all the cases. That's why we're so high. But with the country in the middle of an election campaign in which COVID barely gets a mention, a war raging in Ukraine, a cost of living rising, and following more than 2 years of COVID restrictions, the virus has understandably to some dropped off the radar. So Burner Institute Executive Director Brendan Crabb said he's over it. We all are, but the numbers we are seeing in Australia are extraordinary. So many people are getting sick. And there's also a new flu around that is that is knocking people about as well. So the disconnect comes back to what he describes as a fear of the COVID past and COVID now. He said after 2 years of extreme impacts, governments and politicians were now afraid to talk about COVID. Instead, he said they'd removed mask mandates and kept their heads in the sand, ignoring the key elements of why cases and hospitalizations had now increased transmission. And COVID now, he said, is having a massive impact on society. Remember, COVID is bad for business. We can't ignore that. As a nation, we've been ignoring the health impact of many of the 350,000 plus active cases in Australia now will have chronic impacts. Overseas data suggests 10% of them, and that will impact your heart, impact your lungs, organs, and brains. It's not nothing. According to Melbourne University epidemiologist, the numbers may get worse. We're at the point where COVID is now one of the major killers of Australians, and probably by the end of the year, it's going to be one of the top 3, she said. With the increasing case numbers, new subvariants, this may drive us further and have a bigger impact. The emergence of new Omicron subvariants is complicating matters. Experts suggest the variants may lead people to becoming reinfected, leading to another rises in cases, as been seen in South Africa and parts of the US. Westmead Institute virologist Tony Cunningham, who studied the evolution of viruses for more than 4 decades, said the continued emergence of alternate variants across the world was worrying. We don't know if one of these new variants will acquire the capacity to infect the lungs at the same degree that, say, Delta does. There's COVID all around, and there's more virus in the community. There's likelihood of variants emerging. University of South Australia epidemiologist said cases will go up across Australia. So all the experts are saying the same thing. Our governments are giving messages that's all over. It's not over. I mean, the Prime Minister said that his government had helped lead Australia out of the pandemic. We're not out of the pandemic. We're at the end game. We have reasonably good vaccinations, good treatments, and the least reasonable chunk of the population is immune, but it's not over. One sector of the community actively aware that COVID is not over is the healthcare workers. This week, the Australasian College of Physicians reiterated its need for urgent action over burnout and exhaustion in the sector. There is no respite. The AMA president said healthcare workers felt there was a deliberate glossing over of the ongoing challenges that COVID-19 was putting on the healthcare system. We're a bit stuck. We're treating COVID as it's a cold, say no mask, play on. But there are still a lot of people coming into hospital with COVID, and of course, there's no staff. He said healthcare were fed up, particularly around the messaging from politicians that the pandemic was over. In Perth, where I'm based, they're saying it could be 20 to 25,000 cases a day. We have a lot of anecdotal reports of people not testing themselves, or when they get a positive test, not recording it with the government. Of course, it's impacting healthcare workers. So I know the AMA would like masks to come back, but anyway, at the moment it's it's not mandatory. But anyway, so I don't know whether Peter is still around, but if I'm going to end this now, we're going to end that there. So thank you for joining me. I think I covered everything. I hope that's been helpful. I will do another video on how to vote. A separate how to vote for that. But if you're the replay crew and you've made it this far, thank you for watching. You can hit like and subscribe. There's a thanks button underneath if you want to say thanks. It's like a super sticker, but on the replay. Thank you for watching. Yeah, hit like, subscribe. You can join the channel. I'm hoping to get my I'm working on a revamp of my website, so I'm hoping to get that all up and running soon. I've still got assignments to do. I've still got exams coming up. My brain is fried. Yeah. But anyway, I hope that has been helpful for everybody, particularly the sentencing guidelines in the US. As I said, I'm tipping about 5 years. But, it could be 8 years. and 5 years time, you know, anyway, that's my, as I said, it's just what I've, thank you, Plan to Create, and things are going well on the other front as well, Plan to Create. So, which has been occupying me a little bit more as well. I spend my weekends now at the football. So, yeah. So, anyway, that's a story for another day, but I will catch you all later. I'm going to put the timestamps below, and thank you for joining me. Anyway, so until next time, bye for now.